Namaste, Jai Hind, and welcome to this edition of The Right Stand. I'm Anand Narasimhan. It's a big boost for Bharat, ladies and gentlemen. FPIs or foreign portfolio investors have pumped in $20 billion in Indian equities till December 2023. And the 20th of December, actually, this is the data. This is the second highest in the last decade. In 2020, FPIs invested $23 billion in Indian markets. Andrew Holland, CEO Avendus Capital Alternate Strategies, has said that Bharat is actually a great consumption story and its consumption story will attract investors in the coming future too. Meanwhile, Union Education Minister Dharmendra Pradhan has informed the Rajya Sabha that the enrollment of girl students in schools increased by 31% between 2014-2015 and 2021-22. Dharmendra Pradhan has also highlighted that a 50% rise has been seen in the enrollment of female students, especially from the scheduled caste. The Education Minister attributed these outcomes to various initiatives launched by the government led by Prime Minister Narendra Modi. Dharmendra Pradhan also highlighted that since 2014, the total number of students enrolled in schools and universities has increased by 26.5%. The Lok Sabha Speaker has said that 74% productivity has been recorded during the winter session of Parliament. Om Birla said that Lok Sabha held 14 sittings and worked for 61 hours and 50 minutes and that 18 bills were passed in this winter session. The Modi government, meanwhile, is on a mission to expand the coverage of Ayushman Bharat, Pradhan Mantri Jan Arogya Yojana. Government aims to add 270 million beneficiaries by the 26th of January. More than 280 million individuals have already an Ayushman card, which entitles the holder, someone below the poverty line, accessible quality health care. Now, quickly getting to other big news that's just coming through, and it's around the Delhi Chief Minister Arvind Kejriwal, where after Kejriwal skipped the second summons, here comes the third. The Enforcement Directorate has issued Delhi Chief Minister Arvind Kejriwal a third summons in the Delhi excise policy case. And this after the first two summons were skipped by Arvind Kejriwal. In fact, with the second, he called the summons itself illegal and the ED politically motivated and urged the ED to repeal or take back the summons. Shankar Anand joining us with more details from the Enforcement Directorate headquarters in the national capital. Shankar, namaste. बताइए details क्या है? ये तीसरा समन है. अगर इसका भी जवाब अरविंद केजरीवाल ना आकर देते हैं तो क्या होगा?
निश्चित तौर पर देखिए आनंद, इस वक्त की बड़ी खबर कही जा सकती है कि दिल्ली के मुख्यमंत्री अरविंद केजरीवाल को केंद्रीय जांच एजेंसी ईडी यानी प्रवर्तन निदेशालय के द्वारा एक और सम्मन भेजा गया है। और ये सम्मन जो भेज करके उन्हें 3 जनवरी को, यानी कि जब नया साल के जश्न में पूरा देश झूम रहा होगा, उस वक्त में पहले सप्ताह में ही 3 जनवरी को उनको पूछताछ के लिए बुलाया गया है और पूछताछ के लिए ईडी मुख्यालय पर यहाँ पे बुलाया गया है। जिस तरह से अगर पूरे मामले की बात करें तो जिस तरह से दिल्ली सरकार की जो पूर्व आबकारी नीति मामले में जिस तरह से भ्रष्टाचार देने का आरोप कई लोगों पर लगा था और इस मामले में तफ्तीश का दायरा लगातार आगे बढ़ता हुआ नजर आ रहा है और इन्हीं तमाम मसलों को ध्यान में रखते हुए मुख्यमंत्री अरविंद केजरीवाल को पूछताछ का यह सम्मन भेजा गया है। और 3 जनवरी
अगर ये तीसरे सम्मन को ऑनर नहीं करते हैं और वो उपस्थित नहीं होते हैं तो फिर क्या होगा? उनके नाम का वारंट निकलेगा?
निश्चित तौर पे देखिए उनकी मुश्किलें और ज्यादा बढ़ सकती हैं। जो पहला समन भेजा गया था वो 2 नवंबर को भेजा गया था, लेकिन वो नहीं पहुंचे। दूसरा समन जो भेजा गया था उनको बुलाया गया था 21 दिसंबर को, यानी कि कल बुलाया गया था, लेकिन वो नहीं आए। और अगर इस सम्मन पे भी अगर वो नहीं आते हैं तो निश्चित तौर पे उनकी मुश्किलें बढ़ सकती हैं। और क्योंकि ये तीसरा सम्मन होगा और कई बार देखने को मिला है, कई बड़े बड़े जो लोगों के खिलाफ भी देखा गया है कि तीसरे सम्मन के बाद कई बार मुश्किलें बढ़ जाती हैं। तो निश्चित तौर पे कहा जा सकता है कि अगर इस सम्मन को भी अगर वो नजरअंदाज करेंगे तो उनकी मुश्किलें बढ़ सकती हैं और देखना लाजमी होगा कि 3 जनवरी को क्या पूछताछ की प्रक्रिया में हिस्सा लेने के लिए मुख्यमंत्री अरविंद केजरीवाल आएंगे या नहीं।
बहुत बहुत धन्यवाद Shankar Anand. So Shankar Anand getting us that update right from outside the ED headquarters. A third summons on the 3rd of January. If Kejriwal doesn't present himself, then he faces an arrest warrant against him. So it's going to be a politically heavy and exciting start for 2024. Let's move on here on The Right Stand and let's set up the debate number 1 tonight on this Friday edition, ladies and gentlemen. And the question is, we have a Suraksha Sanhita, a Nyaya Sanhita and a Sakshya Sanhita, which is totally Bharatiya. But why oppose this?
क्रिमिनल प्रोसीजर कोड और एविडेंस एक्ट, ये तीनों कानून अंग्रेजों के शासन की रक्षा के लिए बनाया गया था। उच्च सदन की अनुमति प्राप्त होने के बाद एक नए युग की शुरुआत होगी जो पूर्णतया भारतीय है।
These laws are draconian, they are authoritarian, they will lay the foundation of a police state in India. These laws will be challenged in the appropriate courts of law.
जिन्होंने पूरे सिस्टम को बदलने की कोशिश की है, लोगों के, नागरिकों के मौलिक अधिकारों को बहुत आसानी से छीनने का प्रयास किया है, CrPC, IPC और इंडियन एविडेंस एक्ट में संशोधन करके।
Codes that are totally Bharatiya. The Parliament passing 3 criminal law bills, the Bharatiya Nyaya Sanhita replacing the Indian Penal Code, the Bharatiya Nagarik Suraksha Sanhita replacing the Code of Criminal Procedure or CrPC, and the Bharatiya Sakshya Sanhita BSS, which replaces the Indian Evidence Act. Prime Minister Narendra Modi called the passage of the bill a watershed moment and a new era. Begins with laws centered on public service and welfare. He also added that these transformative bills are a testament to Bharat's commitment to reform and ensures protection for the poor, marginalized and vulnerable sections of society. But the opposition claims the laws are unconstitutional and draconian. Opposition claims that on the one hand the laws penalize common man and on the other they weaponize the police. The question that we are asking is, are you opposing it because it is Bharatiya? And if it is Bharatiya Nyaya, shouldn't all welcome it?
Hello, Moto.
Sanju Verma, National Spokesperson of the BJP with us, Vivek Bansal, Political Analyst, Sumit Chandar, Advocate, Supreme Court and Vikram Singh, former DGP, Uttar Pradesh with us. Namaste and Jai Hind to everybody and seasons and festive greetings to everybody in advance. We're building up to a weekend of festivities, but the opposition is not very, very happy. Sanju Verma and Vikram Singh ji, first up, Vikram Singh ji, आपने तो वो फेमस फिल्मी डायलॉग ही चुरा लिया, ये कहा जा रहा है तारीख पे तारीख, अब हम किसको बोलेंगे? Sunny Deol ji bhi will be upset. One of his iconic moments will now are rendered useless. Vikram Singh ji.
बिल्कुल आनंद जी, याद कीजिए, there was an act by the name of MISA, Maintenance of Internal Security Act, POTA, TADA. This is not even kindergarten stuff in comparison. Those draconian laws, happily they have been repealed. But the fact of the matter is, I as a police officer would have been very happy if confession made before an SP was admissible. It is not. Any confession made before a police officer is not admissible. Uniform handcuffing is not allowed. Happily so, as an Indian I feel, but as an ex-police officer I feel, when I'm handling terrorists, those who are accustomed to making their escape, yes, a small window has been given in that. Then, in case of petty offences, I'm not in agreement. There is provision of community service so that the jail population is diluted and the jails can become more humane. Then witness protection program. Have we heard of this provision earlier? I haven't heard it, and this is being introduced. This is nothing short of a positive revolution, Anandji, and disagreement for the sake of disagreement. I would like to understand in what way is it draconian. As far as Sanju,
so as a former police officer, sir, one of the key arguments is that this is weaponizing the police. These laws will turn Bharat into a police state. So let me ask you, because somewhere a little bird told me that you also have a key role in the reform of these bills and the more Bharatiya aspect of these bills. So let me ask you, how would you take that criticism?
I was very disappointed that the police has been the whatever vestiges of fangs that they have also been taken away. When I said before that a confession made before a police officer continues to be non-admissible, I would have been very happy, as in the case of Puda and Tada, that confession made before a DSP was admissible. Handcuffing again is with checks and balances. Then also that sedition laws, I'm very happy about that. There are clear-cut demarcation between Deshdroh and Rajdroh. Deshdroh, zero tolerance and non-negotiable. But against the government, it is perfectly that sedition charge has been removed. Mob lynching has been identified. Organized crime has been identified. And also punishment in respect of rape, marriage by deception. All these things have been, which you have discussed on your show multiple times.
Ji.
All these have been in what way you're very right. I think collective wisdom of so many vice chancellors, law graduates, lawyers of the Supreme Court, judges, all have gone to make these acts, and I feel absolutely satisfied that this is the wonderful statute and nothing short of a positive revolution.
Is that why lawyers are upset, Sumit Chandar ji, कि अगली तारीख तक हम पोस्टपोन नहीं कर पाएंगे? ये तारीख पे तारीख वाला एस्पेक्ट ही हट गया because there is a time limit.
No, that's not the reason. But let's be very clear here. There are various aspects. We are first the officers of the court. So now I will speak from the point of view as to what law is now come up and what the Supreme Court has said. Has it really gone against it or aligns with what Supreme Court has says? Now Supreme Court, like Learned DGP has rightly said, use of handcuffs. Supreme Court time and again in various judgments has held that using of handcuffs.
Sumit ji, go ahead.
Am I audible?
Yeah, now you are audible. We lost you momentarily. Please go ahead. So, using of handcuffs, what has the Supreme Court said? Ji.
Supreme Court says use of handcuffs is inhuman, unreasonable, arbitrary, and repugnant to Article 21 of the Constitution of India. Now, if Supreme Court makes such a statement and it's part of a constitutional right of every citizen, I think use of handcuffs should not have been there anywhere under the new act. However, in certain provisions, certain places, they have still allowed the use of handcuffs.
They've excluded economic offences out of the handcuffing.
Yes.
And petty crimes has also been, and also based on the seriousness of the crime and of course the deviousness of the deviant, I think there is some measure of who needs to be put under handcuffs and who can be excluded. So that somewhere is fair.
Now, if something is unconstitutional or against Article 21 of the Constitution itself, I think it has to be taken more seriously rather than casually allowing it in certain places. Secondly, even if I look at the new provision, which is Section 152, which now gives the new form to the sedition law, it's interesting where all the provisions allow in law giving the liberty to the magistrate or the judge to use his discretion as to what number of years should be given in imprisonment. Here now the new provision says it's either imprisonment for life or the punishment would be imprisonment which may extend to 7 years. Now it does not leave the discretion to the court to decide how much it is going to be, which is unreasonable here. Then again, Supreme Court in several matters have held that there should not be vague terms used. If I look at, and that was majorly in Shreya Singhal versus Union of India, where Supreme Court held that some provisions can be unconstitutional if the terms used are vague and devoid of precision. Now, if you look at the provisions used in the present new law, there are provisions which clearly use vague terms, like the learned DGP had rightly said. If you look at Section 4F, which talks about community service as a method of punishment, but it lacks a clear definition of what activities would constitute community service. Similarly, Section 111, which relates to organized crimes, the explanation, it uses the word economic offences without a clear definition, vague such as financial scams, Ponzi scams, mass marketing frauds. Now, without providing explicit definitions of these terms, you cannot just vaguely mention that these are the offences or these are the schemes.
Okay, Sumit Chandarji, you've highlighted a few words and few terminologies which are ambiguous. I urge you, sir, please move an urgent petition in the Supreme Court to very clearly define the term minority in our Constitution, to very clearly define the term secular in our Constitution and who should be secular and who should not. Who is minority and who is not. Certain core terminologies in our Constitution itself are so ambiguous and nobody has challenged them. And we have so minutely, you have been able to dissect the terms, and I kudos to you, sir, that you have highlighted these concerns. They are genuine concerns. But since you've got such a sharp eye, I urge you, sir, since you're an advocate in Supreme Court, to please direct the Supreme Court's direction in clearly defining who are minority in our country and who are not. Because ये बहुत बड़ा बखेड़ा इसकी वजह से ही हमारे देश में चल रहा है. But Vikram Singh ji, how would you respond? How would you respond to Sumit Chandar? And then I'll go to Sanju Verma and Vivek Bansal ji. Yes, Vikram ji. Some terms which could have been better defined.
Yes, indeed. There are always, Mr. Sumit Chandra is a learned lawyer and I respect him for that. I learned the basics and rudiments of law from him. Now, coming to the fact that the brass tacks, yes, it is always good and prudent to give examples in case of sticky and contentious issues, as is the case of the former Indian Penal Code. But yes, like any law, it evolves with time. It comes and develops an edge with its implementation. But the fact of the matter is that what Mr. Sumit ji has said requires a hands-on experience of an investigator. A skillful investigator would be able to find out what sedition is and what is nothing. Hindustan tere tukde tukde honge, inshallah. I think nobody in his right hands would be able to digest this and would name it as sedition. Afzal hum sharminda hai, tumhare qatil zinda hai. And that is where I feel that the police should have been given more powers to handle people who are raising such slogans. And also, there is no doubt, we are only focusing on the very grey areas which perhaps would require a debate. But any such sensitive investigation, the police takes legal opinion, the legal opinion is then vetted by a superior prosecuting officer, it is supervised by a senior police officer, and then goes to the judicial scrutiny. It is not that the sub-inspector does not like my face, and merely because he does not like my face, he just puts a charge sheet. It is totally unacceptable. There are multiple tiers of evaluation, taking of opinion, and then submission of the charge sheet. Therefore, I feel it is a wonderful statute. Give it an opportunity to be implemented, and I'm sure nothing is fail-proof and nothing is foolproof. But yes, all grey areas have been addressed. Mob lynching has been addressed, which was we have discussed so many mob lynching.
There are critical aspects which have been addressed, that agrees, and that there is some perhaps merit where you would say at least test the law. If there are errors, we will amend it and we will improve it. If the draft itself can be changed over 3 days, 9th December it was tabled, then it was withdrawn, and 12th a fresh one was brought because there were words and there was numbers, and it was pointed out there are errors. So there have been this government has even reworked the entire draft for our drone tech licensing and the drone Drone Act itself the whole draft was changed in less than 1.5 years. The whole act. So if there is merit, then yeah. But why oppose for opposing sake, Vivek Bansal ji? इन न्याय संहिताओं से तकलीफ क्या है? और जो सही में अगर कोई प्रॉब्लम था तो विपक्ष तो बाहर बैठा हुआ था. आपको तो ये डिबेट करना चाहिए था सदन में.
बैठा हुआ था, विपक्ष को बाहर बैठाया हुआ था. Deliberately they did not want that विपक्ष opposition should participate in the as far as threadbare discussion is concerned. विपक्ष को बिठाया गया है. विपक्ष the MPs had been suspended.
Vivek Bansal ji, sorry to interrupt. You please continue after my just 30-second intervention. If you and me agree that if you stand up on the bench, you will be asked to stand outside class, then there is an instruction which says we are discussing something important, and you decide to stand up on the bench and you're standing outside class. So can you blame the person who's saying we are going to discuss something important, or should you blame the people who stood up on the bench?
No. There is some immediate provocation, and for that they wanted a discussion on that. So why just scuttle it?
They were sir, you know it very well. They were not suspended because they protested. They were suspended because they protested in a manner which they themselves agreed attracts immediate suspension. That is holding a placard.
No. They basically wanted a discussion on, there was a serious breach of security, and I think
Vivek ji, you have the right to protest, but you don't have the right to hold a placard. You and me have agreed that any one of us who does it will attract immediate suspension. After that also you do it and you get suspended. No, it's not my fault. You can't find me.
Holding a placard, more of till the time you are registering your protest. What is till the time it is non-violent. If the speaker is not,
then you and me should not have agreed. No, sir. Then you and me should not have agreed with Speaker Sanju Verma that if we hold the placard, we will be suspended. That's where it starts. My point is, sir, 18 bills have been passed without proper proper interventions and discussions and weighing in of the opposition in the Lok Sabha.
Heavens would not have fallen. Heavens would not have fallen if they would have gone for a discussion on the issue. Heavens would, and I think it was a serious matter in itself.
Sir, what was more serious? The Criminal Procedure Code and discussing these 18 bills, और to stand sure and say स्पीकर के बोलने से काफी नहीं है, रक्षा मंत्री के बोलने से काफी नहीं है, जब तक गृह मंत्री नहीं बोलते तब तक हम प्लाकार्ड लेके खड़े हो जाएंगे, बाहर खड़े हो जाएंगे, लेकिन प्लाकार्ड लेके खड़े हो जाएंगे. Who is serious and who is not, sir?
आप डिस्कशन तो उस पे करते हैं, आप उसके
No,
बाद
sir. Okay, let's come back to the Nyaya Sanhita. Let's come back to the Nyaya Sanhita. Sir, have you read the 3 bills, sir? Have you read the 3 bills, or have you just decided because it's this government that's done it, so it's draconian?
It is the responsibility of the treasury benches also. They should have gone. It was not. It was not.
Mr. Bansal, I am asking you, Mr. Bansal, I am asking. Like I said, you break a rule, you'll get fined, irrespective of who you are. You broke the rule, you hold a placard, you get suspended. Now, if you missed out on something important because you got suspended, then it's your fault. My question to you, sir, have you read the 3 bills? Do you have a problem with the 3 bills?
No. Having a problem. You see, that there would be no bill in itself is perfect. Let me tell you that. If you have a threadbare discussions, definitely you reach to a point where the grey areas or where the suspicion of the opposition or where there are some loose areas, they can be.
What is your single biggest concern with the 3 bills? What is your single biggest concern with this bill? Sir, Sumit Chandarji raised his objections. I am asking you, what is your single biggest concern that you would like the BJP spokesperson to address right now about these 3 bills?
Definitely, as you see, as we have been saying, police in itself have been, as it is, police as very, very arbitrary in this country. And with these bills, they would definitely, with these draconian bills, they would definitely further, bulldoze the general people. I don't say that.
Sir,
definitely, whatever criminals are there.
Okay, Vivek Bansalji, are you willing to serve as a police officer at a police station for 2 weeks? And then will you hold the same opinion? Wear a khaki uniform, serve as a proper sub-inspector or an inspector or as an SHO in any place of your choosing. Wear it and then you tell me, sir, will you have the same opinion?
I would, Mr. Anand, I would also like to...
There is a former DGP of Uttar Pradesh in this panel who was part of the recommendations committee, and you are sitting here and just passing judgment on the entire police of our country. 1:720 people, that they are weaponized and they have too much of power. It is 1:720 people. That's the average 2 years ago, sir. That number has only gone up. And you are saying this. Okay, Sanju Verma.
Anand, I'm now getting into the debate 20 minutes hence. I have not heckled anyone. And it is very clear that, Mr. Bansal has not read any of the 3 bills, because he refused to answer your pointed questions. He was simply going round and round in circles and, indulging in whataboutery. Now, I don't wish to be heckled. I'm making this very clear. What is it? I've not even started.
Please go ahead. Please go ahead.
Thank you. First and foremost, I think, let's be very clear that from bringing terrorism and organized crime under the ambit of ordinary criminal law, introducing gender neutrality in offences pertaining to children, to repealing section 377 that criminalizes homosexuality, I think the BNS is a watershed moment in criminal jurisprudence, and I'll tell you why. I read the bills not once, not twice, not thrice, but at least half a dozen times to get the larger picture. And what I found very interesting, Anand, is that this whole narrative that police has been given disproportionate powers is a whole lot of hogwash, because the magistrate has the authority to, dictate to the police whether the detention should be for 15 days, 60 days or 90 days. And if it is for 90 days, there are ample checks and balances that are in place to ensure that no law is weaponized by the police or anyone for that matter. But more importantly, I just want to tell Mr. Chandar, because, he raised some very important points on definitions and how certain nuances have been missed out. I think for the first time, if you look at clause 69 of the BNS, it obviously, ostensibly and very explicitly seeks to tackle this entire love jihad narrative by criminalizing deceitful promise to marry. The phrase sexual intercourse not amounting to offense of rape, actually now criminalizes any sexual intercourse that has had between two individuals with either the promise to marry, with either the promise to give a promotion to one of the parties, with either the promise to ingratiate one of the parties, or with either the promise to mislead one of the parties under a false identity. And we know that in love jihad cases, the famous case of, Tara Sehdio, who was a national shooting champion, and she married a man thinking he was Ranjit Kohli. But finally it turned out that Ranjit Kohli nahi the, wo to kuch Salman, Atik, Ahmed, Soz, is biradari mein se aa rahe the. But more importantly, I think I always say the devil is in the details, and very quickly in 30 seconds, for the first time, the court has been said that you have to frame charges within 60 days. An FIR has to be registered on real-time basis and no later than 3 days. Then it is said that the preliminary probe has to be finished within 14 days. And then it says that further probe has to be finished within 90 days, 90 days of the charge sheet. The Sessions Court has to give its verdict within 30 days of the completion of the trial. And then it also, apart from introducing this entire concept of community service, which is pretty much a Western concept, but I think very much welcome. I think the fact that in a hit and run case, now they're clearly saying, over and above what was there earlier, now 10-year rigorous imprisonment. They are saying in the case of lynching and mob lynching, is something that has aroused so much of debate in the last 9.5 years. Clearly कहा गया है कि 7 साल की सजा mob lynching के cases में होगी. But more importantly, I think the definition of terrorism. I think this is very important, and I will just take 10 seconds to tell you. I was reading and I found that now the new bill says that terrorism is not just separatism. Terrorism is not just an act that destroys the safety, security, stability of the country, but terrorism also involves the use of criminal force against a public functionary. So the entire section 15 of the UAPA has been blanketly applied to ensure that the definition of terrorism is very comprehensive. But for me as a woman, what I find excellent is the fact that apart from EFIR, abhi bola gaya hai that the victim of sexual violence need not go to the police thana, because don't forget, Anand, that even today in rural areas, semi-urban areas, even very educated women, when they are victims of domestic abuse or sexual violence, they say, "Arey bhai, police station jayenge to badnami to khud ki hogi." Your statement will be recorded at your residence. And most importantly, apart from the whole concept of zero FIR having been empowered, I would like to tell Mr. Chandar that he should also give credit to this government for clearly for the first time defining what cruelty is. If you read section 86(3), it clearly says what exactly comes under the ambit of cruelty, which was earlier not there under section 498A. Because remember, section 498A has been abused by women and has been abused by men also. So, clearly making this section 498 into a gender neutral law and bringing in section 86(3) to define cruelty, which leads to suicide. Because remember that suicide cases में ज़्यादातर conviction होता नहीं है.
Thank you. Sumit Chandarji, please respond. But again, community service, what is community service? Has it been clearly defined? That's a query that Mr. Sumit Chandar raised, and that remains. The other aspect is sexual assault. Is it being made only gender specific, or does that remain gender neutral? If offences against a child or pedophilia or any other kind of assault against a child can be gender neutral, then in this, or the offender can be gender neutral. In this case, the larger question is, has sexual assault been defined only per one gender in the country and not, are the charges not gender neutral? That's another question that remains. Sumitji, would you like to respond to Sanju Verma?
Learned BJP spokesperson has said that I'm just against it, against the law. Let me be very clear, with due respect, as a lawyer, it is my duty to bring out the loopholes in any law. And I'm only trying to ascertain whether the new laws are in line with the judgments and the constitution provisions which are already in existence. So now, say for example, I'll just say another point when it comes to sexuality and gender neutrality. Say for example, Section 377 of the old Act, right, which now has been totally removed. Fair enough, the government decided to do so. But let's see, 377 to totally remove, was it right? Because 377, besides other things, also covered certain provisions, certain specific provisions with respect to bestiality, for example. Now, bestiality is also an offense, used to be an offense, and there have been several instances of bestiality. In fact, latest even in times of in 2022, where bestiality offense was committed. Now, bestiality, sex against animals, sex with animals. Now, that unfortunately, however absurd it may seem, it is happening in the country. And that also is removed just because 377 in Navjot Singh Johar, Supreme Court said that yes, it can be, to a certain extent modified. So to mindlessly change things is also not right. So my as a lawyer is to just bring to the notice of the government that see, these are the provisions which could have been modified. Now, another very important aspect which needs to be seen, a lot of other acts, the provisions of other acts depend on IPC. Where, say for example, the provision where it says the Juvenile Justice Act, Section 84, it says that for the purposes of this act, the provision of Section 359 and 369 of IPC would apply. Now, of course, those provisions have changed. So now, just by changing the entire act, changing the sequence of the provisions, the government also parallelly should have immediately amended the other provisions which were relying upon the IPC. So those aspects still need to be worked upon. It cannot just change.
Right. Sanju Verma wants to respond, and then I'll take the query to Mr. Vikram Singh. Yes.
Anand, the best thing about your debates is that they are so sane. And you do so much of thorough homework that the panelists have to be on their very best when it comes to preparation. I just want to add to what Mr. The learned advocate from the Supreme Court, Mr. Chandra, said. I think one very important thing which nobody seems to be mentioning on this panel is the fact, and I will again say as a woman, the consensual sexual intercourse with a wife above 15 years of age was not a crime earlier under the IPC pertaining to the year 1860. And now it says that the consensual sexual intercourse age limit with a legally wedded wife, because remember, in some cases there are tribes, there are people who get their daughters married off at the age of 15. All that will obviously change after the Uniform Civil Code. But at this stage, that limit of 15 years has been raised blanketly to 18 years. So even if it is a wife, यदि आपने 18 साल की लड़की के नीचे, उम्र की नीचे, even if she is your wife, if you engage in sexual intercourse with her, it is a crime punished by law. But last but not the least, I always say that justice delayed is justice denied. जो आनंद जी ने कहा तारीख पे तारीख पे तारीख, I think these three provisions are the most important. In cases of lesser crimes, FIR has to be filed within 3 days of complaint. For offences punishable with punishment of between 3 to 7 years, preliminary investigation will have to be completed within flat 14 days. And FIR will have to be registered on the same basis, and detailed probe has to be completed within flat 90 days. इसका मतलब चाहे कितना भी जघन्य अपराध हो, no matter the gravity and intensity of the crime, the entire process of charge sheeting and completing the investigation should not exceed 90 days. I think that's the beauty of
what has also happened in this case, and if you could look at the bills broadly, is that if the police have been empowered, then they're also put under pressure to actually act and to complete investigation at a stipulated time. They can't drag on the investigation. So if you are empowering the cops a little more and the police a little more, then you're also putting the pressure on them to actually go ahead and complete the investigation fast. Investigation in a manner that will hold in a court of law, and the court of law is also under pressure to go ensure that there is no the issues are settled at a much faster pace. So the intent is not that something is being questioned. The fact is that have all the aspects been fully thought through. I know I'm running out of time, but quickly, Vikram Singh ji, some aspects, some concerns raised by me, raised by Sumit Chandra ji, which continue to remain. is the recourse for justice gender neutral, especially in cases of sexual assault? Has community service been properly defined? The absence of the IPC now, especially in reference to certain aspects like he mentioned, Sumit Chandraji, has that been looked into? If certain acts have been formed with reference to some other acts, now if those acts get abolished, then what happens to these rules and these laws? Has that been looked at?
Now, very good. Anandji, I would like to say that by natural justice, all sexual assault cases in the past also, and I'm sure in this case also, are gender neutral. Now, coming down to the fact that cross-referencing of various acts, this is a matter of detail and it follows through. Once this act has been passed, and I believe it has been passed, not much time has elapsed, and therefore the cross-referencing and other minor amendments will take place in a matter of time. But yes, there are certain follow-up measures that are to be taken, and they are taken in due course. As Mr. Chandar had mentioned, the relevant provisions of the Juvenile Justice Act need to be updated, and it's not only the JJ Act, it is so many acts that have cross-references, and they have to be dovetailed and amended accordingly.
So some amendments are still to be made,
Anand,
some
just 10 seconds.
improvements are still to be made. Now you've redefined the entire criminal code and the criminal codes of the country. Any thoughts on defining minority, defining what is secular? Sanju Verma ji?
Anandji, you're asking me a tricky question, but for a change, I will digress because, speaking on that right now as the national spokesperson of the ruling party is going to land me in trouble. But I will just say this. I'm surprised nobody has mentioned that one of the most, I think, important changes is that the government has said mercy petition can now not be filed by any NGO or third party. Mercy petition can only be filed by the convict. Do you remember Yaqub Memon when he was given capital punishment? Entire this Candle Brigade, the Lal Bindi Brigade as we call them, this Khan Market gang knocked on the doors of the Supreme Court रात के 12 बजे कि भाई याकूब मेमन को आपने capital punishment क्यों दी है? Now the new law says only the convict can appeal against the Supreme Court judgment, and that too within 30 days if he or she wants to file a mercy petition. तो ये जो NGOs हैं जिन्होंने कारोबार बना लिया था mercy petition का, इनकी तो दुकान बंद हो जाएगी.
Well, कहीं आप शटर डाउन कर रहे हैं, कहीं आप शटर डाउन कर रहे हैं तो कहीं और शटर अप होगा. So we have to see whether you are able to ensure that that is not happening. And there are still some concerns with some of the aspects of this law, and perhaps it will take shape. There will be amendments, and at least if one is open to change, and especially for the better of Bharat, then that is welcome. Nothing is perfect, as Vivek Bansal ji said, no law is ever perfect. But is this something that Bharat needed over a long time, and it is truly Bharatiya in its ethos? Well, we'll have to wait and watch. The jury is out on that. So far, it seems to be on the right track. Thank you very, very much to the lady and the gentleman on the panel.